Hello, and welcome to Virtual Legality. I'm your host, Richard Hogue, managing member of the Hogue Law business law firm of Northville, Michigan. And today, unfortunately, we have yet another story in the video game industry of studio closures, loss of jobs, and in this particular case, a thorny legal issue that I think has really caused my social media timeline to take off. So I want to talk a little bit about that, about patents in video games, because I do see a lot of information out there from well-meaning people that is maybe not as 100% accurate as it could be. But before we start, let's get into this particular story. As Polygon reports, Warner Brothers closes Monolith Productions and Multiverses Studio and cancels Wonder Woman game in a big shakeup at WB Games. And of course, Warner Brothers Games has been the subject of a number of videos in Virtual Legality, primarily because they have been going through a shakeup, not just in their video game productions, but in their movies and television productions after their merger with Discovery. So this is a story that is bad for the people affected. We don't want to discount that at all, but it is not one that we can take as symptomatic of larger issues in the video game industry on the whole necessarily, because this is a very specific problem for a very specific studio, and we have a lot of history with movie studios and people that make media in other industries like movies and television already having issues producing video games. We saw this with Disney and their attempts in Disney Interactive to make games. So this is a bad story for those affected. I don't see it as a story that is emblematic of a giant sea change in the production of video games, or in what some folks on my social media timelines are calling the predecessors of a video game crash. That said, this article says Warner Brothers Games is making big cuts, closing 3 studios, Monolith Productions, Player First Games, and WB Games San Diego, and canceling its long-in-development Wonder Woman game, the publisher told employees on Tuesday. Now, that first game company, Monolith Productions, is the big-ticket item here. They are a video game company, a video game developer of long standing. They've been making games for 30-some-odd years, and they've made some of the most popular games in history, including most recently the Mordor series, Shadow of Mordor and Shadow of War in Middle-earth. And going back a little bit further from that, one of my favorite first-person shooters of all time, No One Lives Forever, which was a James Bond satire send-up that featured the Kate Archer you see pictured here as a spy with kind of goofy Austin Powers 60s British flair in a first-person shooter environment. But we are unlikely to see that game ever come back, even with the closure of Monolith, as put forth in a Kotaku article that is one of my favorite on intellectual property from 2015, that says, the sad story behind a dead PC game, here No One Lives Forever, or NOLF, that can't come back. And in this article, you see some of the issues with intellectual property licensing overall in video games. One of the things that happens when you make a video game is that you're using intellectual property for a number of different sources, including music, including programming. And if you don't take good care of keeping track of where that intellectual property was sourced from, you can lose track of who could possibly make a remaster decades in the future. So as this article says, the question of who controls the NOLF intellectual property has proved famously difficult to answer, and the series has remained unavailable. Or, as it says a little bit further on, thanks to the ongoing inability and or unwillingness of 3 publishers, Activision, 20th Century Fox, and in particular Warner Brothers, the stars of our show here today, to determine who owned the game, Night Dive, which you may be familiar with some of their other projects bringing things like The Thing or System Shock to modern systems, is currently abandoning its efforts to revive No One Lives Forever. Now, here I do want to disclaim that I am familiar with Night Dive. I am friends with a number of the people that work there, including but not limited to the referenced Larry Cooperman here, who actually helped me start my Twitter account and realistically helped me start this journey in Virtual Legality and on YouTube back when he was in Ann Arbor, Michigan, and working with the Game Developers Association. So I do want to say that, just so that you know that in context of this article. But ultimately, the point is Warner Brothers and intellectual property questions are going to be at the heart of what we're talking about with respect to this particularly thorny patent issue and Monolith Productions. So let's take a look at that patent issue right now. Here's another Kotaku article entitled, "The Nemesis system was one of the best things gaming ever did," which might be a bit of hyperbole. Gaming's done a lot of good things, but Warner Brothers just killed it. Warner Brothers is shutting down the team responsible for one of the most interesting narrative design mechanics in recent memory. Now, that's an interesting description of what the Nemesis system is. One of the things we will see as part of this story is that there aren't a lot of descriptions that are terribly useful for understanding what Nemesis is. Part of that is because the patent that was issued for the Nemesis system was written so broadly. It's described here as narrative design mechanics. The easiest way to think about Nemesis, if you aren't familiar with the Mordor or War games, is that it is a design parameter within video games that changes how different NPCs, monsters, enemies in Mordor, in the case of those games, react to things that you do as the avatar, the player character in those environments. And if that sounds too broad to you, well, that's going to be part of our conversation. But what I wanted to talk about first is the way that this is described in these various articles, because I understand why you would think this. The overall story here is that Warner Brothers got a patent. It has the exclusive intellectual property rights to this Nemesis system that was created by Monolith. They closed Monolith over the course of the past couple of days, and now they are the sole owners of it, so it's killed. It's gone, says these articles. But that's not fully accurate. That's not how these things work. The Gamer reports Warner Brothers will still own the Nemesis system until 2036, despite Monolith closure. I did want to give credit to this particular headline because this is accurate. And a number of people asked me when this news came out yesterday, what would happen to the intellectual property? What would happen to the patent? Does it go away when they close the studio that was responsible for its creation? No. Warner Brothers paid for those people to make this thing. As part of that payment, they received an assignment of the patent. When they filed for the patent, they paid for that process, presumably at the same time. And so they, Warner Brothers, not Monolith, was the holder of the patent, and they continue to be the holder for as long as it is effective in the United States. As IGN says, after Warner Brothers shut down Shadow of Mordor developer Monolith and canceled Wonder Woman, fans lament the wasted potential of its Nemesis system. And I highlight here in the subheadline, it's gone but not forgotten. So you see the tenor, the theming of these articles is that Nemesis must be dead because Monolith is no more. Or as Eurogamer put it, Shadow of Mordor's brilliant Nemesis system is locked away by a Warner Brothers patent until 2036, despite studio shutdown, as industry reacts to closure. And in their article, they have a good description of the Nemesis system. It's a clever in-game mechanic, says this author, which tracks a player's actions to create enemies that feel capable of remembering past encounters. In the studio's Middle-earth games, this allowed foes to rise through the ranks and enact revenge. The Nemesis system was set to be utilized again in Monolith's Wonder Woman game, though that project has now been canceled alongside the studio's sudden closure, leaving the Nemesis system seemingly now lying unused and protected by Warner Brothers due to its successful patent application. But one of the things that I wanted to make this video for was to establish that intellectual property is just that. It's property. It is something that can be bought and sold. It can be licensed out. And one of the reasons that you go and you patent things like the Nemesis system, if you're Warner Brothers, is so that you have the ability to control its licensure. Yes, when you have Monolith and you're making video games on your own, you might use it for comparative advantage. You might say, we're the only stop that you can get the Nemesis system at. Don't buy those other games. You only want to buy Warner Brothers games. We have the best recipe for your gaming good time. But if you're not making things with the Nemesis system anymore and someone else were interested in using that Nemesis system, you want to have a patent if you're Warner Brothers so that you can have the rights to license it out by contract. And so I do think now, more than before, more than when Monolith was working on Wonder Woman, it is more likely that we are to see the Nemesis system actually break from the walls of Warner Brothers, if it is of interest to developers out there. And so let's take a look at what I mean when I talk about intellectual property. First, I want to make sure that we understand the differences between these terms because these get confused a lot, and we're going to see some confusion in my social media timeline in just a second. But I want to explain the differences between trademark, patent, and copyright. These are the three main areas of intellectual property. A trademark, as described here by the USPTO, the Patent and Trademark Office, is a word, phrase, or design that identifies your goods or services. Think the words Coca-Cola, or even the branding, for soft drinks, that it identifies that this is a Coca-Cola, this comes from the Coca-Cola company. That's a trademark. By comparison, a patent is a technical invention of some new, unique, and usable idea in a type of industry, or as they describe here, a new type of hybrid engine. And you might say, Rick, You're talking about a video game concept. How is that a technical invention of a unique and usable type for some industry? Well, in this particular case, what we're talking about is really a method patent. It's a way of doing things. So you can't patent, you can't copyright, you can't otherwise protect ideas. You protect the execution of those ideas. You can't protect the notion of the orcs learn about you and they change how they reference you as you go through a game. You can, however, patent the way that you coded it, the way that you had these various parameters interact. And that is what Warner Brothers got their patent in, even though some, I think rightly, think what was issued to Warner Brothers was probably overbroad, that there are ways to challenge it because it's covering vast swaths of what would be gaming interactions of some level of normalcy. Copyright, as our final category, is the one we see most commonly discussed here in Virtual Legality, because copyright affixes to any creative work that you create. The words in the novel that you're writing, the code in the video game that you're creating, the lyrics to a song, the composition of the song, those get a little bit more complicated because music has a bunch of different rules. But the USPTO describes this for purposes of our intellectual understanding as the lyrics to Let It Go from Frozen. Again, I don't like to use music as the example here because there's so many different copyrights and intellectual property protections that go into any kind of musical piece. But that's the difference, right? You've got Coca-Cola, the name, the trademark. In our case, that would be the name Nemesis, even though we're not talking about trademarks here. The patent, a new type of hybrid engine, or the method of having other orcs react to the fact that you killed the first orc in the Mordor games from Monolith and Warner Brothers. The copyright is the code that you wrote to get it to do that in Shadow of Mordor or Shadow of War. Those are the differences between the intellectual property pieces, but people get them confused all the time, including, honestly, and a little disgracefully, at the Supreme Court. But I wanted to highlight this particular Twitter user, Alex Hutchinson, who is a developer who puts out some good information on my social media, as someone that gets it wrong because it's so easy to do. For anyone who is interested, Warner Brothers copywriting the Nemesis system from the sadly shuttered Monolith means nothing. You can't copyright mechanics. You can build something exactly the same. You just can't call it a Nemesis system. So if we're analyzing this for purposes of a legal analysis, we can look at this in sentences. For anyone who's interested, Warner Brothers copywriting the Nemesis system is not accurate. We know that we're talking about patents, not copyrights. Then the next sentence is accurate. Oftentimes when you see these confusions, you see truth next to lies, or at least next to inaccuracies, next to truths, and that makes it all the more complicated. You can't copyright mechanics. You can't copyright ideas. You can't patent ideas. You have to only be talking about execution when we have this conversation, and yet that doesn't lead you to this last sentence, which is you can build something exactly the same. You can't. You just can't call it a Nemesis system. That's talking about trademark, right? So we're using the term copyright in this particular statement. We're talking about it as if it were a patent, and then we're referencing it at the end as a trademark. So all of that's inaccurate. The state of play right now is that Warner Brothers holds a patent to the way that the Nemesis system operates, not the concept of a Nemesis system, which is an accurate piece of this particular puzzle. But I wanted to highlight that because this is the kind of stuff you see on social media, and I want people to be careful out there because even top-level lawyers in intellectual property pursuits get these terms wrong, get the ideas wrong, get the concepts wrong. This is a particularly complex area of law, and so just be careful out there with where you're getting your information because a lot of people make these mistakes. The second aspect of this I wanted to talk about was in a tweet from a synth potato that said, I absolutely think some law firm should look into suing Warner Brothers for patenting the Nemesis system and then proceeding to shut down Monolith. Honestly, I don't think there's any kind of lawsuit here. I'm not looking at this in diligence terms. I'm not going through their paperwork or anything like that. But this is a knee-jerk reaction that I see a lot in video games that says this bad thing affects me, it hurts me, it harms me, I don't like it. Somebody should sue. This is a very kind of American approach to the legal and justice systems. I understand it. I understand the knee-jerk reaction to say something was done wrong and I want to get legal recompense for it. But I don't think there's anything here that is suable over. Some people came into my comments on this particular tweet and suggested intentional infliction of emotional distress, which is funny, but Warner Brothers is not trying to hurt your feelings. If you love the Nemesis system, if you love Monolith Soft, if any of these publishers or studios close a company that you really love, they're not trying to hurt your feelings, they're trying to make money. And that might sound callous, that might sound like it's not terribly responsive to the legal question, but it is. If they aren't trying to hurt your feelings, then you can't go for intentional infliction of emotional distress. And if you're trying instead for negligent infliction of emotional distress, the threshold question there is, do they have a duty to your emotional well-being? And if they don't have that duty, then you're not going to be able to make that claim in most jurisdictions and in most cases. So I get that this is kind of a knee-jerk response. I get that people are going out there and just saying something needs to be done. I understand all of that, but I do want to respond to it in this video because there are 200 some odd thousand views to a notion like this one. And it's important to understand that the law is not designed to just make everything that you don't like illegal or for someone to be legally liable for that thing that you don't like. That said, there are questions, as I've mentioned before, about what the Nemesis system actually does, what was actually protected by the patent that Warner Brothers got. So let's go to the primary source material. So first and foremost, this is a patent that was issued to Warner Brothers entitled Nemesis Characters, Nemesis Forts, Social Vendettas, and Followers in Computer Games. Now, the first thing we see in the abstract, which is again just a summary, it's not the operative language in the patent issued, is that what we're covering are methods for managing non-player characters and power centers in a computer game based on character hierarchies and individualized correspondences between characters and character traits or rank, etc., etc. So we're talking about methods, the actual way that we do this thing, not just the notion that something is being done. Proceeding a little bit further, we can see that the actual claims here, these are the parts of the patent that are legally operative, are that it's a method controlling game events involving an avatar operated by a player and a first non-player character, or NPC, that is controlled in response to the first set of character parameters. So the things we know about how the player character has actually interacted with the game so far. Then, detecting the occurrence of a predefined game event, something we've already programmed in, involving that first non-player character, and changing a second set of character parameters of a second non-player character in the game, and outputting an indication of that change to an output device, presumably your monitor or television for the video game that you are playing. Now, if that sounds overly broad, you say, Rick, you just described I'm playing a game and I affect one non-player character and a second non-player character has certain parameters changed and the game shows me that, and I feel like I've seen that before in other games. I'm not going to tell you that you are wrong. The process of filing for a patent is one in which you file it in the USPTO and examiners go and look and see whether or not what you are describing is something that is novel and new and useful, and you are supposed to disclose all prior art, everything that's already in existence in the industry, so that they can assess whether or not it's already been used. But these examiners are only human beings like the rest of us. So we also have a process in place to say if a patent is issued, you can challenge it either through a federal lawsuit or in the office of the USPTO itself. And yet that hasn't been done at this point in time. It's only a couple of years old since this patent was issued. But one question I would ask of you if you're listening or watching this video is it more or less likely for Warner Brothers to defend a challenge in this particular case without Monolith in their purview? Said another way, I think, again, that regardless of what the headlines say, the exit of Monolith from the playing field of game developers makes it less valuable to hold the Nemesis patent solely in Warner Brothers' hands. Makes it more likely that if someone were to challenge the validity of the patent that we're looking at right now, that Warner Brothers would at least softly yield to some of that challenge, unless it proved that they had some commercial interest in licensing it out in the future. So either way, it's either going to get challenged legally or it's going to be of value and someone else is going to be willing to pay money to have access to the concept from Warner Brothers. And so the loss of Monolith, while tragic for those involved and certainly a sad point for people that loved its games like No One Lives Forever, is not, I think, the end of the story for the Nemesis system. But at the end of the day, that's all going to come down to what you can challenge. And so in the course of preparing this video, as I so often do, I looked at a number of articles on this topic. And for the first time in my memory in Virtual Legality, I found an article that really spoke to me in the words that I'm used to hearing, that really I thought was well-intentioned, well thought of, well thought through. And of course, if you're only listening to this and not watching this, you don't know that I just highlighted an article that was written by me 4 years ago. And in looking at this particular topic, I read this article and was happy to see that the past version of myself, I think, got it right. And so we're going to take a look at this article. We're going to talk about the things that we've already talked about a little bit with respect to intellectual property. And it's better to understand what the likely result of all of this is. So, while patents are not an unusual part of the research, development, and invention creation process at many technology companies, they are a bit more unusual in the gaming industry, is how I start this article. So it was no surprise when developers across the games industry leapt to criticize the move, with some calling it gross, and others using more colorful language. But as is so often the case with legal questions, it's all a bit more complicated than that. To begin with, it's important to understand the foundational principles of intellectual property law in the US. Now, we've already started that process in looking at the difference between trademarks and patents and copyrights, but it's also worth noting why we have any of this. Some people look at intellectual property and say no monopolies on intellectual property should be granted at all. These paragraphs in this article talk about why the US government and many other governments around the world are structured to give term-limited monopolies on inventions and creative works to their authors. You have the exclusive right to control how things are used when you get a trademark, copyright, or patent. The framers of the Constitution believed that this was the best way to ensure continued acts of creation, that books would continue to be written and machines continued to be invented, and in order to ensure that the author or inventor would receive all rights associated with their creation, either themselves or by licensing the rights to another. And that's an important piece of this pie, right? I talked about it earlier, but one of the things that I do in my line of work so often is draft intellectual property license agreements. And that can be patents, that can be copyrights, that can be trademarks, that can even be trade secrets or other kind of confidential information amongst businesses. Or as this particular law firm puts out, any form of intellectual property, from trademarks to patents to copyrights, can be licensed to third parties. Through licensing, an IP owner grants third parties the right to use their IP while retaining their ownership. Another way to think of IP licensing is the leasing of intellectual property for a fee. You're renting it out. Unlike IP assignments, which we talked about earlier, from the makers of the Nemesis system up to their employer, their parent employer, Warner Brothers, is done by assignment, which transfers all ownership of the intellectual property. Licenses provide only limited use, enabling licensees to benefit from intellectual property while protecting the ownership rights of the licensor. So we see this all the time in video games. We actually see this with respect to copyrights. When you purchase a copy of a video game for yourself, that purchase is of a license to use the copyrighted information, the code, on your console, on your computer, in your home, not to broadcast it in your local movie theater and charge entry fees to see it. These forms of IP licensing can take three different versions: exclusive licenses, sole licenses, and non-exclusive licenses. And the primary difference between the first two categories there is that you can essentially write an exclusive license to be that you have licensed out your intellectual property to only this other party and you can't use it yourself, or you can retain the rights to use it yourself while limiting the license out to only one party. And so there are a number of ways that you can draft these things. Lawyers can draft them in all sorts of different creative ways, but the important piece of understanding here is that licensing out intellectual property is part of the reason why you get intellectual property rights in the first place. And Warner Brothers, seemingly in need of revenue, in need of shoring up various aspects of its business, or else they wouldn't have closed down all these studios so suddenly, would be interested in the business of potentially getting unexpected revenue from licensing out the Nemesis system or any other intellectual property rights that it has to what it's already created. But reasonable minds can differ even on that score. So let's continue with the article written by Hogue circa 2021. WB Games pursued the patent over the Nemesis system for the better part of a half-decade, continuing to get its request denied by the USPTO over and over again. Why? Well, you can see for yourself, but suffice it to say, the USPTO apparently had many of the same problems that gamers had had with the news. Is Nemesis really a new invention? Isn't the use of procedural generation for Nemesis pretty obvious based on what had come before? Don't other games basically do all or part of Nemesis already? One examiner even went into a multi-paragraph comparison between the Nemesis system and PC gaming stalwart Crusader Kings, explaining how the claims WB Games made about the Nemesis system had already been implemented in other corners of gaming. And I have as a parenthetical here that I have to admit, I had never seen a Crusader Kings gameplay synopsis in a USPTO filing before. It's always fun when you dive into games filings of any kind because you see all sorts of different things in the USPTO or government filings of all sorts. All of these points are important because U.S. patent law does not allow for a patent to be issued for something that is known by the public before the request or which is an obvious evolution of an existing idea. Or said another way, if we actually look at the law regarding patents, a person shall be entitled to a patent unless the claimed invention was already patented, or going even farther, a patent for a claimed invention may not be obtained if the differences between the claimed invention and the prior art, what's already out there in the world, are such that the claimed invention as a whole would have been obvious before the effective filing date of the claimed invention to a person having, and this is important from a legal perspective, ordinary skill in the art to which the claimed invention pertains. So an ordinary game developer looking at the state of play before this patent issues could have guessed that this was the method that you would use to do something like this if you chose to do it. Then that shouldn't be patentable, that there's not enough novelty. We only protect things that are new in the world. Otherwise, you would quash everybody's ability to iterate and remix and change things in video games or any other industry. And so you can look at this particular issuance and say, well, maybe this should be challenged. And how does that look? Well, it's a costly process. Or as this particular law firm puts it, the validity of a United States patent can be challenged in federal court litigation. Patents can also be challenged in the U.S. Patent and Trademark Office, which in most cases is a quicker and less costly process. The PTO provides 3 procedures by which a patent can be challenged, what they call inter partes review, IPR, post-grant review, PGR, and ex parte re-examination. In IPRs and PGRs, anyone except the patent owner may file a petition to challenge the patent. The filing fees are high, $41,500 for an IPR and $47,500 for a PGR, and those are always changing, so those could be different even today, with additional fees depending on the number of claims challenged, and I believe there are 36 independent claims in the Nemesis system patent. The only grounds that can be asserted in an IPR are anticipation and obviousness, the ones that we already looked at. The only prior art that can be cited are patents and printed publications. Then there's different methods for the PGR and different methods yet for an ex parte re-examination. So long story short on this particular question, you can challenge this patent. You may have been disinclined to do so when you thought Warner Brothers Games was at full firepower and would absolutely defend this to the mattresses, as the Godfather might say. But now, with them cutting ties with Monolith and maybe even the concept of the Nemesis system, they might be more open to being challenged. They might be more open to licensing this out. We don't really know because we are not in the boardroom at Warner Brothers or Warner Brothers Games. We don't know how irrational they might be, but a rational business operating now without the connection to Monolith, I think, is more likely, not less, to actually let Nemesis escape its doors. So I think the headlines, while understandable, and the reactions online, while understandable, are probably exactly the opposite of what the likely outcome of all this is, which is to say, if anybody thinks there is actual interest in a game featuring the Nemesis system, or if an independent developer is making something that could conceivably be associated with the Nemesis system, there might be a reason to go and try to license it out from WB Games just to cut off any future litigation or problems before they happen. So that's what I wanted to talk to you all about today, because I do see sometimes these headlines and the overall vibe on social media being what I view as exactly the opposite of the likely outcome. And I wanted to make sure that I shared that information with you today. Or as I say to finish off this article with VGC, is it gross? I'm not sure I'd go that far, and a number of commenters disagree. But it certainly raises questions for the continued evolution of the gaming industry. In the end, the real Nemesis might just be a USPTO out of its depth and all too capable of being cowed by a well-resourced enterprise. Time will tell. Now, I didn't see time telling it in this particular way, but without Warner Brothers having as strong of a reason to go and defend this particular patent, I'm not sure we won't see Nemesis escape its earthly bounds. That all said, what do you think? I am very interested in your comments or any questions you have on the overall topic of this video. To this video or podcast, please do let me know. Or otherwise, if you'd like to support these kinds of conversations, please do consider supporting us through the Patreon by becoming a member of this channel, where we're trying to give more value by having the Virtual Legality episodes go early a little bit earlier for members than they are for the general public, or by having super chats in our live streams. Otherwise, if you don't want to do any of those things, just subscribing, liking, disliking, Commenting, anything else, or telling your friends we're having these conversations is of supreme help. So thank you so much, and I'll see you on the next episode of Virtual Legality. Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship.